Tēnā koutou katoa. We're just waiting for everybody to enter the webinar, so we'll just wait a minute or two. Kia ora koutou, for those that have just joined us. We're just waiting a minute or two for everybody to arrive. We shouldn't be too long. Kia ora. Excuse me. Oh, kia ora koutou. We're just waiting for everybody to join. We're just going to give it another minute. They're still ticking up, so I'll try and wait till everybody is able to join. Thank you for your patience. Kia ora. Oh, kia ora koutou. It's still, people are still arriving, so just going to give it another, hopefully another 30 seconds to a minute, and then we'll get started. So thank you for your patience. Kia ora. I think we might get started now. The numbers are sort of slowing down now. So tēnā tātou katoa, e hui hui mai nei I whakarongo ki tēnei hōtaka, nau mai haere mai. Ka tuatahi, ka tukumihi ki te tari o te mana Whakatipu I whakarite I tēnei hōtaka, kei te mōhio mātou, he maha ngā mahi I muri I tēnei hōtaka, nō reira ka nui te mihi ki a koutou. O te rā, ki a koutou katoa, kua tai mai, kua whai wā ki te whakarongo mai ki tēnei hōtaka. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko wai au, he uri tēnei no te Aotea waka ko Ngāti Ruanui, ngā ruhine, ngā rauru, ngā iwi, engari I te puaki au ki Porirua, I raro I te maru o Ngāti Toa Rangatira. Ko lana o tawhirihuria tōku ingoa, ko au tētahi o ngā tumuaki o kāhui legal, he pai ki te kōrero ki a koutou I te ahiahi nei, nō reira tēnā koutou, tēnā koutou, tēnā tātou katoa. Kia ora koutou, it's lovely to have you all here and lovely to be part of this Privacy Week series. I'd just like to firstly say a mihi to the Office of the Privacy Commissioner for organising today, and then also just a big thank you to you all for joining in. So my kōrero today was entitled Māori Data Sovereignty and Intellectual Property. And as you'll see from the slide, I've added and privacy because we are in Privacy Week this week. And so I will try and wrap those three topics up together and hopefully send you away with some interesting things to think about. One I do want to acknowledge my colleagues that I have been working on, or I contributed to in a small way to an article on Māori Data Sovereignty and Privacy that was published by Te Ngira, the Institute for Population Research, and the team there. A lot of what I'm going to talk about is going to come from that paper, and I just want to mahi to the team, and in particular our esteemed leader, Tahu Kukutai, who carried the bulk of the burden in the production of that article. So just a mahi to them. So Māori, what we're going to start off with today is, firstly, we're just going to talk briefly about Māori data. What is Māori data? Then look at what is Māori data sovereignty, and then explore intellectual property and think about how Māori data intellectual property could potentially provide a framework for Māori data sovereignty, and then examine potentially other options that may also exist to help acknowledge and protect Māori data sovereignty. So we'll jump right in. Excuse me, that didn't quite work. So this time, so what is Māori data? So there's lots of definitions out there that you can find around what is Māori data, and it's important that we do take quite a broad perspective when considering what Māori data is. So from Te Mana Whakatipu in 2018, the definition that they provided for Māori data is the first one there: digital or digitisable information or knowledge that is about or from Māori people, our language, culture, resources, or environments. And so if we think about what that might mean, it encompasses and includes our traditional knowledge, and the traditional knowledge that reflects the relationships that Māori people not only have with themselves, but also with their language, culture, resources, and the environments around us. And then a shorter definition for Māori data from Te Kāhui Raronga in 2021 is still quite a broad definition, but it provides a little bit more context in that Māori data is data that is by, for, or about Māori, but also any data that Māori have a connection to. So not less prescriptive in the definition, but in terms of the breadth of what that definition might cover, it is fairly broad, and we need to think about data or Māori data in that sense. It is really broad and covering a wide array of areas that are by, for, or about Māori. So when we think about Māori data and then try and think about what does Māori data sovereignty mean, and this definition is one that is taken from an articles, I should say, written by many in this area. And this definition in particular relates to Indigenous data sovereignty and talks about the inherent rights and interests that Indigenous peoples have in relation to the collection, ownership, and application of Indigenous data. And so if we analyse that definition in a little bit more detail, and it establishes that Māori or Indigenous people have these inherent rights and interests that they have in relation to data, and those rights relate to not only the use of that data, but also the collection of it, the ownership of it, so who owns it, and then how it is used or how it is applied outside of that. There are other definitions about for Māori data sovereignty, but I think one of the key aspects of Māori data sovereignty and that it acknowledge an element of control and authority that is inherent in the word sovereignty. So how do we achieve, this aspiration of Māori having sovereignty over their own data? We have another definition here just to provide a comparison. It's one from Karaitiana Taiuru, which provides a lot more information, a lot more detail about what that control might look like, including creation, collection, access, analysis, interpretation, management, dissemination, reuse, and control. So again, expanding on that control, what's inherent in the word sovereignty, control, authority, use, and the use expanding to include just about any use of Māori data. So I mentioned that the intellectual property framework, we're going to look at that and consider whether that can help address the issue of data sovereignty. And so therefore it's important to understand what intellectual property is and where its origins are and the principles that underpin it. So intellectual property is this idea. It's a concept that has developed overseas. It has origins primarily in America and in Europe. Its origins were really altruistic originally, in that it was developed to help protect artists and inventors and ensure that their creations were protected and protected for them to be utilised in the manner that they saw fit. But in more recent times, we've seen it become quite a tool, a commercial tool that is used to maintain competitive advantage, maintain control, stop others from using, and really used as a tool to create wealth for commercial enterprises. But at its heart, intellectual property is about recognising these new and innovative creations of the mind. And as an intellectual property lawyer, I will have people come to me quite regularly and say, I have this new idea for a new invention and I want to IP it. So they want to protect this idea. Unfortunately, an idea in itself is not protectable within the intellectual property system. There has to be some tangible or intangible manifestation of that idea for it to have some type of protection within the IP system. And so therefore these intellectual property rights are obviously based on a new or innovative creation of the mind, but they also have to manifest in a tangible or intangible expression of that idea. And then as a result of those two things, we then have these things called these assets, which can be owned, controlled, gifted, transferred, or commercialised. And if we think about the aims of Māori data sovereignty in terms of owning, controlling, gifting, transferring, access and management of that data, then you can sort of see the alignment here with the intellectual property system, and that there are similar outcomes that you can achieve from the intellectual property framework that align with what we would like to see in a Māori data sovereignty framework. So what does the intellectual property system grant? And it effectively grants you these intellectual property rights that form these assets that you have control over. And these intellectual property rights are granted on the basis that it is giving effect to a social contract between the creator and the Crown, and that you will be granted these rights for a limited period of time, and in return you will be given a monopoly to enable you to exploit and commercialise those rights at the exclusion of others for that period. So what the intellectual property system then grants you are these registered and unregistered rights that enable you to protect aspects of those innovative and those creations of the mind. And these are the rights that we have. We have the registered rights here, the patents, which protect inventions, the way that something works, and in some cases compounds as well, and the actual products themselves. Designs protect the way that something looks, the shape of something, or a two-dimensional or a three-dimensional shape, how something looks. Then we have trademarks, which protect a sign, which can include a name, a logo, a design, a sound, a smell, a three-dimensional shape as well, as a trademark, and enables you. The key function of a trademark is to distinguish your product from other traders. We have domain names, which are the website addresses that we utilise every day. Plant variety rights, which protect species or new species of plants. Geographical indications that protect names, usually that have a geographical names that are associated with a particular area and a product from that area that has a particular characteristic. And then we have unregistered rights like copyright, which is, which can be copyright works, which include things like literary works like books and posters and newspapers. And then we have musical works, which includes lyrics and then the actual musical score. And there's a wide variety of other copyright works. Trade secrets are fairly obvious by the name, confidential information, and then unregistered trademarks as well. So if we think about these intellectual property rights and think about Māori data in the broad sense in terms of it including traditional knowledge and information in general, then we can recognise that aspects of Māori data can be protected within the intellectual property framework. We can protect an invention that may be based on, or maybe an improvement on, for example, a hangi pit, a new way of performing, digging a hangi pit that could potentially be registered as a patent, but that's built on traditional knowledge. Trademarks feature names, designs that have Māori kupu and Māori images within them. They can be registered as trademarks, etc., etc. If we go through each of these rights, we can find aspects of mātauranga or traditional knowledge, Māori, mātauranga Māori, Māori data included, can be protected within this intellectual property framework. But if we actually compare the idea of Māori data sovereignty and those concepts of, authority and control, we can see there's quite a difference here. It's not the same. It's not the same ideas. It's not the same protection that Māori and Indigenous peoples around the world are seeking in relation to their Indigenous data and in Aotearoa Māori data. And so there's a bit of a disconnect there. So whilst we can acknowledge that some aspects of Māori data can be protected in the intellectual property framework, it probably doesn't fit. And most of our IP laws, if we think about them, are actually inconsistent with these key frameworks. If we think about taonga, the protection of taonga that was granted under Te Tiriti of Waitangi, the recognition of Māori values such as kaitiakitanga, and in particular kaitiaki relationships, both individual relationships and collective relationships with data, and how those are regulated through kawa and tikanga and a te ao Māori perspective of how we should view our taonga. That is quite different to what we see in the intellectual property framework, which has these concepts for protection and for patents. If we look at patents, for example, as a requirement that it must be new and inventive, it has to be have inventive step, it has to be non-obvious. For trademarks, they have to be distinctive and registrable within the trademarks framework. These values are not necessarily inconsistent with the te ao Māori perspective, but they just are not aligned. And so we have this continued conflict between our intellectual property laws, our mātauranga, our knowledge, and if we extend that out, that includes our Māori data. And so therefore, recognition of Māori data and Māori data within the intellectual property system is not right, it doesn't fit. And so therefore we need to consider something else. And so this has been considered wonderfully, within the Y262 decision. If we look to the Y262 decision, which has been called a number of things, including the Mātauranga Māori claim, has been called the intellectual property claim, the flora and fauna claim, the Te Ao Māori claim. So it's been called a number of things, but it does provide some guidance on what a framework for protection of Māori data and Māori data sovereignty might look like. And if I think in my view, we can find it in these two statements here that within the decision that talk about the protection of Māori culture. And if we take Māori culture to be part of Māori data, then Māori data is included within that. And that it's necessary to protect Māori culture and identity because that is how we protect New Zealand culture and identity. And so what that statement means is that it is incumbent not just on Māori to protect Māori culture and identity, and that we can include Māori data in there, or I'm going to include Māori data in there, because that is how we protect New Zealand's culture, identity, and New Zealand's data, if we extend that out as well. And so therefore, our law should make room for these relationships between kaitiaki and their taonga works, taonga species, and mātauranga to flourish as a matter of national interest. And I'm going to extend that out here and say, you know, our laws should make room for the relationships between kaitiaki, Māori data to flourish as a matter of national interest. So we have some guidelines there, some recommendations about what needs to what should we should be protecting, what we should be enabling to flourish. And as I mentioned before, it is incumbent on all of us because this is a matter of national interest. It's not just a role for Māori to play, it's a role for tangata tiriti to play as well. So if we think about, if I sort of summarise sort of where I've come from today in this webinar, and also what's explicitly said in the Y262 report is, you know, our intellectual property laws do not protect those kaitiaki rights and interests. IP rights can protect aspects of mātauranga/data, but are not sufficient for mātauranga/Māori data to flourish. So we need to develop other structures and regimes. These need to be established. And these, if we think about it's a matter of national interest, then these regimes and structures need to be established as a matter of priority. Excuse me. It's also important for us to consider another important decision from the Waitangi Tribunal, and that's the Y2522 claim, which was a claim related to the CPTPP free trade agreement, and it also, it challenged the digital chapter in particular. There was a specific, there were three parts to the decision. The third part focused on the digital chapter, and in particular, the lack of, you know, the fact that that chapter breached the rights of Māori under Te Tiriti. And so some of the recommendations that came out of that report confirmed that one, mātauranga is a taonga, and that therefore Māori data is a component of mātauranga because it can incorporate Māori data can incorporate mātauranga. And so therefore digital governance and regulation has implications for the integrity of mātauranga Māori. And the chapter that was under consideration was looking at digital governance and regulation, especially across borders. And therefore, because mātauranga Māori, the integrity of mātauranga Māori is at risk within that digital governance and regulation, then it's vulnerable. And so therefore the Crown had its duty of active protection was heightened as a consequence. So it was what the decision went on to say was that the exception provision within the free trade agreement was insufficient to address the vulnerabilities to mātauranga Māori within the digital chapter, and that exception provision was not sufficient to meet the Crown's obligations of its duty to actively protect mātauranga Māori within that digital governance framework that was proposed in the CPTPP. And so the government needed to do more. The report itself did not go on to make specific recommendations about what the Crown needed to do to address this, the shortcomings in this chapter. The report did acknowledge two pieces of work that were underway, in particular Te Pai Tawhiti, which was the government's response and work that it was involved with in response to Y262. And also there was at that time the review of the Statistics Act underway, which provided the opportunity for the government to address some of the concerns that were being raised in this claim. That Act has been reviewed and is now, the Act has now been passed into law as the Data and Statistics Act 2022. And I'm going to talk about that a little bit more in a minute. But what the report for Y2522 did recommend was that there needed to be ongoing dialogue between Te Tiriti partners to help address the issues that were raised in this claim, and in particular the issues around the vulnerability of mātauranga Māori and Māori data within the digital chapter, the digital governance chapter that was negotiated in CPTPP. Unfortunately, on my understanding is those dialogues are moving quite slowly, and we've seen that chapter repeated in the UK Free Trade Agreement and then the UK Free Trade Agreement, UK and then the EU Free Trade Agreement. So there hasn't been changes made to address the concerns that were raised in this claim. So excuse me. So I mentioned that I was going to talk a little bit more about the Data and Statistics Act 2022, and the reasons being because of this idea of does it provide another framework that we can look to that can help recognise the rights of Māori in relation to Māori data, and also establish a Māori Data Sovereignty framework. There are three sections within this new Act that talk to the rights of Māori or talk to Te Tiriti. We have section 14, which imposes duties on the statistician to recognise the interests of Māori in data. And the interests of Māori include the collection of data, the production of statistics, access to and use of data for research as tools for furthering economic, social and cultural and environmental well-being of Māori. It also requires the statistician to recognise the interests of Māori in the way in which the data is collected, managed and used for the protection of official statistics and for research. And so we've seen an improvement here. There's a recognition of Te Tiriti and the Data and Statistics Act. There's a clear statement that the statistician must recognise the rights of Māori in data. And there's also a clear statement in this section that the Crown has a responsibility to give effect to the principles of Te Tiriti. Section 15 also introduces some principles for engaging with Māori, and these in relation to the collection of data. So these engagements must be early. They need to include discussion on the ways in which the statistician can effectively engage with Māori, and consider opportunities for Māori to partner with a statistician. So again, an improvement in that there's a requirement that the statistician starts to engage with Māori, especially in relation to the role that the statistician has in collecting data about Māori. And then in section 49, when carrying out research, then the statistician must also take into account the risk of harm to Māori in determining whether the proposed research is in the public interest. And again, this is another improvement because there's an obligation to make sure there's not there's no harm to Māori in the collection of data, but as we know, there is collection of statistics on Māori that are not always taken from a Māori perspective, and so therefore it's important. It's again an improvement in the framework, but I think we can also recognise that whilst there's improvements, there's still not. It still doesn't reach as those aspirations of achieving Māori data sovereignty that are spelled out at the start of this webinar. Oops, sorry, I can lose my frame. And so we have seen, in addition to the Data and Statistics Act 2022, as part of the follow-up to that in September 2022, which was shortly after the new act came into force, the government announced that they were undertaking or investing in an initiative that would see the improve the collection of data for Census 2023. And in particular, there was another initiative that was launched called Te Mana Whakatipu, which was an initiative that was going to be led by Te Kāhui Raranga in relation to the collection of data for the 2023 census. And in particular, the appointment or establishment of 2 iwi collectives that would be appointed and responsible for collecting data for the 2023 census in 2 areas, in the far north and in the East Cape, by Te Ohua and Toitu Tairāwhiti. And so those that pilot was undertaken and was part of, was involved in the census collection data this year. Obviously, at that time, we were plagued by a number of weather events that impacted on the collection of data in a number of areas. It wasn't just in those 2 areas, but that pilot was undertaken, and it will be exciting to see the outputs from that collection and how we're starting to see that the delivery of Te Mana Whakatipu sort of, pursue those aspirations of Māori data sovereignty that we talked about at the start. It is important to remember, though, that this is just in one area. This is just in the census area. So if we think about the definition of Māori data, where that arises, it is in every space. And so there is a need to continue on this journey. So if we think about if we take a step back and sort of think about some of we've got Māori data sovereignty. So I'm just trying to collect my thoughts here. We've got Māori data sovereignty. We've got the intellectual property system, which doesn't quite fit. We've got the some guidance from the Waitangi Tribunal about what might be appropriate. Regimes that need to be in place and sort of the underpinning values and principles that need to underpin those new frameworks. We've had a new Data and Statistics Act come into force, which improves upon the previous situation, but doesn't quite reach those aspirations. And then we have had some a court decision that has examined the ability for Māori to access data and come up against some of the issues that are, from our privacy laws, and the concern, really resulted in which provided us with some really interesting, a really interesting decision and some really interesting recommendations that could influence how our Māori data sovereignty framework might look and shape. And so that decision was the Pou Matakana Ltd case versus the Attorney General, and was a case about Te Pou Matakana wanting access to individual data around vaccinations in a particular rohe, because they wanted to target those people to help to ensure that they did get their vaccinations and help improve the or reduce the potential impact of the COVID-19 pandemic on Māori. The Ministry of Health refused to give that information on the basis that that was private information and they were not able to disclose that information. Te Pou Matakana went to the courts, and the courts agreed that the ministry should release that information, and the reasons why they agreed that they should release that information is that te tiriti and tikanga are relevant considerations when deciding whether to share Māori data. The ministry, as part of its mahi and as part of the COVID-19 initiative and vaccination initiative, had committed to upholding and honouring te tiriti and its principles in its vaccination program. This commitment created a really legitimate expectation and a requirement that the Crown must follow through on upholding te tiriti in this vaccination program. And so what the court did was it balanced two taonga or two issues in particular. You know, there was the individual's privacy rights versus the public health in the midst of a global pandemic. And there was also evidence submitted as part of that case that tikanga supports the iwi ability to access that Māori data held by the Crown in the interests of protecting health in the midst of a global pandemic. The decision, so as a consequence, the decision held that the data should be released. The decision was also very critical of the fact that the Crown had already given access to other Māori entities to the same information. They weren't subject to the same, well, they were given access for a start, but they also weren't subject to some of the other restrictions that were imposed on Te Pou Matakana in particular. And also, you know, it provided a real basis that the Crown must live up to. If it says they're going to stick to comply with te tiriti, then they have to. And that's a good basis for us to shift into, okay, what does that mean from a Māori data sovereignty perspective? What does that mean that the Crown must do when balancing these interests of Māori data sovereignty and the privacy interests at the same time? So if we now turn to the Privacy Act and what's in the Privacy Act and how that could influence a Māori data sovereignty framework, we find that the Privacy Act is really focused on personal privacy, personal protection of personal information. At its best, it ignores the rights of a group or collective unless those rights are aligned to the rights of those individuals, the individual perspective. It's important to note that even though this Act was just passed quite recently in 2020, there is no te tiriti clause within the Act, but there is a mention in section 21.7 that the Privacy Commissioner must take into account cultural perspectives on privacy. But it's important to think about the Privacy Act in the context of the wider legal frameworks that we exist in. And there is a lot of case law and a lot has been written about how we interpret our pieces of legislation, even in situations where they do not have a te tiriti clause. And the first case to talk about this was the Huakina Development Trust and Waikato Valley Authority. And in particular, the judge said in this case, there can be no doubt that the treaty is part of the fabric of New Zealand society. It follows that it is part of the context in which legislation which impinges upon its principles is to be interpreted. So when considering and taking into account cultural perspectives on privacy, the Huakina decision implies that the treaty is a part of the fabric of New Zealand society, and so therefore it must inform how the Privacy Commission takes into account these cultural perspectives, especially in relation to privacy. And if we think about, the case law has followed since 1987. There's been many, many cases since there that have talked about interpretation of legislation in the face of the te tiriti or waitangi, irrespective of whether they have or they don't have a te tiriti clause. And so we have developed this principle of legality, where there is a presumption that the Crown does not intend to legislate contrary to fundamental rights or rights that are enshrined in te tiriti or waitangi. And therefore, any intention to override those rights must be expressed and it must be clear. So if there is no express or clear statement that runs contrary to the principles of te tiriti, then it must be inferred that the legislation is consistent and must be interpreted in a manner that is consistent with te tiriti or waitangi. And so if we think about that in relation to the Privacy Act, that it implies that we must interpret this act in a manner that's consistent with te tiriti and all that the principles that are within te tiriti, the words of te tiriti, and what does that look like? And even though it has a particular focus on personal and private information. And we can find help to help guide us on what that looks like from a Māori Data Sovereignty perspective, and principles that have been written and produced from Te Mana. These are from Te Mana Raunga's Māori Data Sovereignty principles, which provide guidance on how we can balance those rights within the privacy, the individual rights within the Privacy Act with te tiriti, and also being more consistent with Māori Data Sovereignty. And in particular, we need, these three concepts, which are explained, you can find them on the Te Mana Raunga website, but they are whangangatanga, so balancing rights, so balancing the individual rights versus the collective rights, accountabilities, holding those to account that are, that are using, having access to, and using in a way that may not be consistent with the Māori Data Sovereignty framework. Manaakitanga, respecting, ensuring that the data is used in a manner that is consistent with a te ao Māori perspective and consistent with te tiriti and consistent with the use of a taonga. And then ensuring that you have free, prior and informed consent. Free meaning without obligation, and free also meaning that you have the ability to say no. We then have prior, which is obviously before use and not retrospectively, and informed meaning the idea that when you're seeking consent, the other person is fully informed, is aware, that understands what the consent is being given for, and it is limited to that consent. So there is a need to, if you wish to use for something else, then you must go back and get consent again. And then kaitiakitanga, ethics and restrictions, ensuring that there are that kaua and tikanga inform how and how the use of that data is regulated, and then restrictions obviously are, there are restrictions, including those that recognise tapu being sacred or restricted data, for example, and making sure that uses are consistent with those restrictions. I just see there's a lot of comments. I'll come back to those at the end. I'm nearly finished, so we can have a bit of a question and answer session at the end. So again, we think about, if we go back to my thought process throughout this webinar, we have Māori Data Sovereignty. We've looked at the Privacy Act and the problems that the Privacy Act had, or the concerns that we have with the Privacy Act, and the lack of recognition of a Māori Data Sovereignty framework that incorporates not just individual rights, but collective rights. And these principles providing a basis to be able to acknowledge those collective rights. And then if we go to, and these are specific, more specific concepts of privacy that would be reflected within a Māori Data Sovereignty framework. And these are what's proposed in the article that I mentioned right at the start, the Māori Data Sovereignty and Privacy Principles. And I'm going to sort of talk directly to these because they are important principles that have been worked on by many, and important to kind of understand those broader, what these concepts mean, so that then these can be reflected in that framework that we're talking about. So whakapapa is central to any concept of privacy within Te Ao Māori. Whakapapa is a genealogical layering and ordering that is of linear descent in time and lateral of kinship space. And that's a kāwharu definition. So it's critical that there is a relationship, a whakapapa connection to the data, and that this is recognised within that Māori Data Sovereignty framework. There's tapu. Tapu is essential. It's an essential element of a Māori data privacy concept, because tapu defines what is restricted, what is unique, what is special, and so that can be applied to both individuals, but also collectives, but also inanimate objects and places. And the reason why this concept is important is that it places a value on that data. It places value on it. It recognises the value of the data that is of concern. Within the next concept that we have is mana, and it refers to authority and power, and it acknowledges, that Māori have the authority and power over their own data. It's important that this is encompassed or incorporated into a Māori Data Sovereignty framework. Modi is refers to the life force or the essence of everything, and it also recognises that everything has Modi. And so therefore recognising that data has Modi, recognising that, or especially data, that data is a taonga, that taonga have Modi, and we need to maintain that Modi, we need to nurture that Modi, we need to ensure that it is cared for and looked after in a manner to ensure that that Modi continues to exist and exist for future generations. And that lastly, we have Ho, which is referred to as the spiritual breath of life, or the divine spirit. It is the power encompassing everything and ensures that everything is healthy and vibrant, and it is embodied in all persons and things. It represents a state of well-being and a state of balance. So if we consider those ideas together, we have this whakapapa, which recognises connection. We have tapu, which recognises when something is special, and so therefore there's a need to protect. The mana recognises the authority and where the authority lies and who the authority lies with, and that's with obviously with Māori in relation to Māori data. We have these obligations of maintaining mauri, maintaining life essence, maintaining life force, and then ensuring that there is this balance, and that encapsulates this idea of balancing those individual versus collective rights, and ensuring that there is balance across all. So those concepts, so if we take the Te Mana Raronga principles and we take these concepts further, then they can provide the basis for our Māori Data Sovereignty framework. That can be a new regime, a new system that will help protect our Māori culture, our Māori, our Māori identity, because that is what is in the interest. That is a matter of national interest. I think that's my last slide. Okay, so we still need a bit of work to do. There's still a bit of work to do to kind of align these ideas of Māori data sovereignty, the intellectual property framework, and the privacy framework. And some of the ideas that Aotearoa is working on is a Māori data and information code that will sit within the Office of the Privacy Commissioner. But the other mahi that we're quite focused on is a new sui generis framework that gives effect to these concepts, the Māori, that gives effect to a Māori data sovereignty framework that will reflect and encompass the ideas that I've talked about today, and in particular the idea that we have a framework that is consistent with Te Tiriti, consistent with the Te Ao Māori perspective, but also consistent with this idea that we are protecting our data, our mātauranga, in a manner that enables that to flourish, and also as one that we as a country as a whole has an interest in, and it's important for us to do so. So, kia ora tātou katoa. We've come to the end of my my slides. I know that I'm going to just turn this off and then stop sharing my slides. Then I can answer the questions that I have, which are quite a few. And I'm happy to there's a question, the first question that we have here is that is there a view that Māori data should be pulled out of collections, which may in turn skew the results? And I don't think there is that view. I think there's a view that there needs to be, when those results are circulated, generally there's been no input from Māori, and there's been there's been no input from Māori, especially around the analysis of those results. And so there's been a particular perspective placed on those results, which is not really consistent with the Te Ao Māori view. And so the idea is that we wouldn't pull the Māori data out, excuse me, but there would be a recognition that there needs to be a change in the way that data is managed. I think that's, I hope I've answered your question there. Lots of them are just concept. There's a question on, not sure I can answer those. I'll try and find, some of them are sort of specific questions that I probably would have to answer separately. So questions asked about the sui generis framework, please. Is that a framework for Māori data or for privacy? I think it's, I think there's a combination, it's a combination of dealing with a sui generis framework for dealing with the overlap between Māori data sovereignty and also the potential clash with privacy. There's kind of, there is a need to recognise this collective Māori collective rights, and it just doesn't fit within the current privacy mandate or Privacy Act, because it is purely focused on this personal information. So having a framework that can at least embrace this idea that there's a collective interest in collective information and collective data. So there is a need for that specifically. There's a question about, can Māori data sovereignty draw inspiration from the GDPR and the rights afforded, especially to individuals within that legislation? So the GDPR is, again, very focused on individual rights, but one of the good things about the GDPR is that they do have these sort of subsidiary pieces which actually do acknowledge and reflect do require acknowledgement of Indigenous aspects, Indigenous relationships with data. It's aspiration. I'm not sure that it has actually been implemented and given effect to those Indigenous perspectives as we had hoped when the framework was developed. But we probably need to monitor that a bit closer, and I think there is definitely parts of it that could align with what we're talking about here. I think I just have room for one more question. I'll just go to the last one here. Of the Māori privacy principles, what do you see as the greatest hindering of these from becoming a base, such that organisations may need only a single policy covering all data? I think probably, as with most things, is probably the control, the ownership and control. And there is a real need to, devolve control and devolve ownership, and that's not something that organisations, if we think about general organisations, both private and governmental and organisations, it is difficult to give up control. But I think that's where it becomes a real partnership, and it needs to be, there's an understanding of what's in Te Tiriti. It is about a partnership. It is about working together to solve those problems, and they can be worked through. It just may take a little bit longer, but there is scope to figure out the answers and figure out the solutions. And I don't think we should shy away from that. I just think it's time to think about a different perspective. There isn't just one perspective of how to look at these things. There are other perspectives, and a Te Ao Māori consistent perspective, to Te Tiriti consistent perspective, is just another perspective that we can consider these things from. I think that's probably my time. Nō reira, ka nui te mihi ki a koutou katoa, kua tā mai ki te kōrero, ki te kouwhau, ki te hōtaka i te ahi ai nei. A tuku ka riri ngā mihi aroha ki a koutou katoa. Tēnā koutou, tēnā koutou, tēnā tātou katoa.